Robert Eglett for plaintiff, Your Honor, and Mr. Parker's outside on the phone, and he'll be in as well.
Okay.
Good morning, Your Honor. Maggie Federico for plaintiff.
Good morning, Brandon Swixler for plaintiffs.
Brad Johnson, Tyler Watson, Michael Esposito, and Eric Freeman on behalf of the defendants, Your Honor.
All right, Mr. Kent.
I just wanted to point out that there's been no evidence introduced during the trial that Blaine Jones is a plaintiff. Remember, they asked the court to take judicial notice of that. I just don't want Mr. Johnson to have an oopsie and bring that up. And the other similar concern is at various times they've made the allegation that I actually represent Blaine Jones. That's not true. Mr. Christiansen represents Blaine Jones, but there's no evidence on that either. So I just don't want either one of these two little oopsies to happen today. That's it.
No oopsies.
No oopsies
No
today?
oopsies today, Your Honor.
All right. Is there any other issues before we bring the jury in?
No, Your Honor.
I know we have this up here. I don't think I need that. Thanks.
Are we talking about the Elmo?
Yes, sir.
All right, fine.
Watch out for that cord. That's it. No.
Any other issues
No, sir.
from the plaintiff?
No, Your Honor.
Your Honor.
Okay.
Your Honor.
One other point that's, it's if either side needs to use exhibits that have been admitted, please make sure that our court clerk knows that, because you just can't take them and use them, because she's actually the keeper of all admitted exhibits. Everybody understand that?
Yes, sir.
All right. Anything else on that?
No, that's it.
All right.
We also ordered lunch again today, just so that everyone knows.
Okay. And it's 5 to 11. I guess we have to get started, don't we?
Yes, sir.
Is he going to get the jury?
Yes.
Robin, I have you on the screen.
And Mr. Johnson, how much time do you think you'll take? And will you take whatever time you need? I'm just wondering.
An hour and a half max.
Okay.
I think that will work perfectly. The lunch should arrive too about.
Yeah,
1:30.
and so we'll go to lunch after you're done.
And Your Honor, and Ms. Mercer, I have a laptop for the jury. I'm gonna give it to Robin to review. All rise for the jury.
All right, do the parties stipulate to the presence of the jury?
Yes, Your Honor.
Yes, Your Honor.
All right, ladies and gentlemen of the jury, I just want to say good morning to you. All right. And it's my understanding we're going to continue on with closing arguments. And at this point, we're going to hear from the defense, Mr. Johnson, sir. And you have the floor.
Thank you, sir.
And I know we have one little housekeeping issue we're dealing with, and thank you, sir.
Good morning, everyone. This is defendant's closing argument. We've waited a while. I know you all have been very patient. First of all, I'd like to take the opportunity to thank the judge and the staff and the marshal for all the help they've provided in this case, as well as my co-counsel, as well as plaintiff's counsel. We battled it out in this case, and so now's the time for us to address closing arguments, what we believe that the evidence will show and what we believe the damages are. Because we've always stated from the very beginning of this case, this is a case that's about damages. Fault and causation have been established, and we've tried to focus on that throughout the case, focusing on what matters, why you're here, and that's establishing the damages to these folks that have been sitting out here for shoot, it seems like it's almost a month now, right? So now it's gonna come down to it. You go ahead and start, Robin.
Switching screen. It's loading.
Okay.
Hey Shane, you have the switch? Good.
Our position is that once it's been established that there's fault liability and there's causation, meaning someone was injured, and we have to determine what damages are, still, despite all of that, real water is entitled to a fair review of the evidence as well, prevent an unjust outcome. In this case, there's been a number of images that have been presented to you. There's a monster thing with rock, and there's a spaceship, and there's Buffy, the vampire hunter. And those are outstanding arguments to present to you. Comment upon that. But our position is these type of images and arguments appeal to the emotion of people. You know, bad guys and good guys. Emotional appeals. As you know, based upon the hearing of the jury instruction, we need to focus on the intellectual aspect of our job here to be fair. Because you can't be fair when you're emotional. You have to be detached and look at the facts. But for the vampire slayer is irrelevant to this case. The rock and the monster here, my client isn't a monster. Spaceships, these people out here are people. It's humanity, that's what this case is about. Never lost track of that though. An issue came up in this case in opening. Why would a defense attorney ask you if you knew about illusory truth, psychological manipulation? And that came up the other day. And the point why that was brought up to somebody who had that type of background is we're focusing on the facts of the case and we don't get distracted by issues that aren't germane to the case over and over again. So on occasion, you'll hear people being asked throughout this case, primarily experts, about, well, is something possible? Could it happen? Etc. A lot of these folks have testified almost to the person that they are concerned about their future, the possibility of things happening as it relates to their mental well-being, you know, getting psychological care, etc. But don't confuse that with what the court has established in terms of what the burden of proof in terms of medical testimony is. It has to be within a reasonable degree of medical probability. That's not, could it happen? That's not, is it a possibility? Anything's a possibility. Additionally, what can be stated over and over again? Counsel did a great job on the good news video. I thought it was pretty funny, you know. But it is good news. It isn't all bad news. And we're going to double down on it in this case. Tell you about the good news. The sky's not falling. But also keep in mind is that's a two-way street. As you guys now know, this isn't a case about, there's no babies in this case. There was a young man, Ms. Olvera, been here all through. He's not a baby. But babies were mentioned in this case 57 times. I'm not going to put up a baby video, but it's 57 times. Why is that brought up over and over again if they're not plaintiff, if it's not to appeal to your emotion? Additionally, it's been stated numerous times, and we don't dispute it, hydrazine can cause death. Hydrazine can cause liver transplant. That's undisputed. That's been brought up a number of times, too many to count. But as you know, in this case, none of these plaintiffs died, and none of these plaintiffs had a liver transplant. So you can say babies, you can say liver transplant, you can say death, you can say all of those things over and over and over again, and it can sink in. And that's why I think it's important that you understand that. That's why we brought it up. Jury instruction number 29 addresses that specifically. Now, the jury instructions, to be clear, are not highlighted and underlined like this and bolded. But neither sympathy nor speculation is a proper basis for determining damages. Damages is what we're about. Sympathy are the images that we discussed. And speculation is the business about, could something happen? Is it a possibility? According to the jury instructions, neither sympathy or speculation is a proper basis. Ladies and gentlemen, this isn't a case about the attorneys. This is a case about the plaintiffs and the parties and you. We have not appealed to your emotional or sympathetic tendencies, I believe. You'll make that determination. We believe that we've appealed on our defense to focus on their intellectual ability to evaluate the evidence. So let's get to it. We talked about the outbreak. Evidence that was presented in this case is really a timeline of 2 times as it relates to these plaintiffs. In 2018, 3 of these plaintiffs consumed real water and got ill. 3 of them. They include Ms. King, Mr. Delmar, and Ms. Bordenave. I don't see her, but you all know Ms. Bordenave. Those were in 2018. Then there's a period of time, and then in October of 2020, there's an outbreak of numerous folks, including most of the remaining plaintiffs who got sick. That was in October of 2020. It was in that time frame, the evidence presented was that Blaine Jones got sick too in 2020. You have to remember that, and I'm sure that you do. You also remember that Blaine Jones has been drinking real water all during that period of time. Even after he gets sick, he's drinking real water. To paraphrase an argument that was made in closings yesterday, if that doesn't scream out unconscious as opposed to conscious, unconscious disregard, what does? That alone would suggest that Blaine Jones, who, when it's not the attorneys being the bad guys, as he's the bad guy, that he was not consciously, intentionally, or willfully harming himself, much less anyone else. Ladies and gentlemen, plaintiffs have the burden of proof. And defendants always say this, like, hey, it's all on them. It's a lot easier, although this case is certainly different, to tear down a house than build it. They built the house. Their house is very strong. Their house says you're liable and you have damages. But they still have the burden of proof to establish what those damages are. And it's our job to look at it carefully to determine if the damages that they're asserting are consistent with evidence and present the contrary argument to you guys. That's what we've tried to do throughout this case. That's why we take the depositions. That's why we cross-examine folks. And that's why we want to keep them to the word, because that's what we rely upon to prepare for trial. There have been comments in closings about, and this is why this matters, why didn't the the defendants call this witness? Why didn't they call that expert? For the very reason, that's what we're arguing about here today. It's about damages. We frown on bringing in witnesses They're testifying about issues that have already been determined. Epidemiologists, things of that nature, it's already been determined. Why would we bring in witnesses like that? That would be a waste of time. We've been here 4 weeks. It's their burden of proof, not ours. And for that reason, we focus on what? The claims. What are the claims? Let's get to it. I actually want to take a close and start at the end and go backwards. You ever see people say that? You know, people are long-winded. Hey, start at the end and go backwards, get to the point. I'm going to do that because I think that's important. Why? Because y'all have a lot to consider. Here is how we believe the damage in this case should be broken down. I'll go into that, and then I'll get into, it may be tedious, but I think it's important, each and every plaintiff. But let's start at the back and go forward. So you can understand what our philosophy is and our understanding and our theory on what this case is about. There's categories of claimants in this case. We've always said they're not the same. We've never considered Ms. King's case be identical to Ms. Bordenay's case and vice versa amongst all of them. But based upon the evidence that was presented in this case, it became fairly clear there's categories. There's folks who had an acute liver injury. It's one of the first things we did, and when we tried to describe it in the opening. Acute liver injury. You may feel as though you're a liver expert by now, but if you don't, I'm fairly certain we have established an acute liver injury is a significant injury, not denying it, but it's lesser than an acute liver failure. Some folks have this, some folks have this. These values are different. Autoimmune hepatitis, that's where parts of your body start attacking their own livers. We would agree this is more serious than that. Autoimmune hepatitis and MG, that's at the top. That is the case with most value and most damages because that's what Mr. Eglitz has proven. That's who he's brought in, and that's why we've agreed to large portions of the damages she sustained, and we'll get to that. We've also agreed to pass damages for these folks, and these folks in terms of their medical care. The last, I don't want to be pejorative, but Ms. Strong and Ms. Casillas, that's a whole different category because Ms. Strong didn't have any medical folks come in at all. She did go to Sands, the site guy, and Ms. Casillas didn't have anything. She didn't go, there's no records of doctor visits and didn't go see the site guy. This is a person who said she had indigestion through it. So these people, if we're going to rank them, we feel it's up here. So that's our philosophy on establishing damages. They're not all the same. They're each different. They each deserve to be looked at separately and completely. So let's double back to the great news. Now, from the defense standpoint, great news may be bad news to the plaintiff's side, but it's great news. What is that great news? For the vast majority, except Ms. King and Ms. Bordenay, the symptoms have subsided. There's no follow-up needed, no monitoring, no psychological treatment. That was across the board, by the way. Ironically, the only person who said they got psychological treatment was Ms. Casillas, but never produced any of that stuff. But that was pretty steady, as y'all know, when we went through. No one went out and got psychological counseling despite the recommendations of Dr. Sands. And now we're talking 7 years after some folks and 5 years after others since the exposure. But based upon that, no psychological treatment as of today. No current treatment ongoing except checkups. Occasionally have checkups. Those checkups are positive, thank goodness. Except, again, carving out Ms. King. No medications are being provided. And ultimately, no limitations. Well, let's keep going with the good news. Let me go back one.
I got it.
Got it? There you go. No liver transplants. No one's waiting for liver transplant. No one has cirrhosis. Dr. Hudson said 90% of people who suffer from, that's right, acute liver failure, including the plaintiffs in this case, recover from their liver injury and do well over time. Dr. Hudson said 100% of the people who suffer acute liver injury, remember that's another category, don't give them any more hydrazine and they'll recover. That's the great news. Notice that none of this is attorney argument. Those are the facts. And if you don't believe me, but I know you do, we'll play some of those facts. And remember, these are witnesses, not attorneys. I think you got some volume problems. Answer, that's correct. That's that question. The 10% that are still in questions. Okay. 90% all are at liver transplant. Answer, that's correct. That's that question. The 10% that are still in that category that aren't dead or have liver transplant, what is their rate of relapse? Answer, it's low. It's certainly close to 0%. Question. Okay, all right. That's good news too. Is that correct? Your answer, correct. Did I read that correct?
Yes. Will you hear when Mr. Kemp was doing the opening statement, he talked about encephalopathy being a brain condition that causes confusion and blood pressure? Yes. Well, you didn't have that, so that's good news. Correct.
And you did not have any current health concerns. Is that correct?
Yes.
And you stopped taking the medication, Xiaphoprine?
I was diaphragm.
Stop taking that?
Yes.
That's good news?
Yes.
If your labs have still been normal?
Yes.
That's the great news. Continue.
Yes.
So, so PTSD with a normal limits, cognitive impairment with normal limits. We talked about that, right?
Yes.
And then Dr. Sands is going to be able to give you a lot as to a variety of different potential personality problems as well.
Evidently.
Okay. And overall, this is great news, isn't it?
It is.
And as you sit here today, and this is my last question, Mrs. Chen, no treating physician, any of the treating physicians, has recommended any additional care as a result of you consuming the water.
Yeah.
Yeah, that's great news.
Yeah, of course, it'd be for anybody who went through what we did,
I
yes.
agree. Thank you very much for your time, Mr. Chen.
That's not attorney argument. Those are facts. Let's talk about the plaintiffs. What I intend to do now is, for those of you, and it's an incredible amount of notes you've been taking, for those of you who want to go through plaintiff by plaintiff, I've broken it down plaintiff by plaintiff. So what I'm going to show is what we believe was going to be presented. Basically, it's the identical riveting PowerPoint that we presented to you in our opening. And then short vid clips, hopefully no longer than a minute or two, substantiating that from the plaintiffs themselves or the witnesses related to their care. So, no particular order, start with Ms. Van Buren. As we say in the opening, she did a follow-up visit with her doctor in January 19, 2021. It was unremarkable. Lab results have all returned to normal. As we stated in our opening, last treatment was 2.5 years ago. Not currently treating for injuries. Is able to do all things she could do prior to her injuries. And we've got a 1 minute and 53-second video addressing those issues in whole or part.
You had any CT scans?
No.
How about
No.
how about any diagnostic imaging?
No.
Let's talk about your blood. Just don't get blood work.
All of it. All within normal levels.
Did you ever end up seeing a neurologist with these?
I did not.
And I believe you treated with a liver specialist in Dr. Medic.
Yes.
And your treatment with Dr. Medic consisted of a couple of office visits.
3 or 4, 3 at least.
And the last follow-up visit, at least at the time of your deposition, was in August of 2022, is that correct?
Yeah.
You haven't seen that doctor since August of 2022, the liver specialist?
I have not. I just am in my primary care's care.
At the time of your deposition, you testified to be not been treated with mental health.
Correct.
Has that changed?
No, I still am not seeing somebody specifically for just my mental health.
I understand how that you died, and I know current treatment for real water.
Correct.
Getting back to the summary, now you have liver function tested once a year, correct?
Correct.
Current treatment, testified to.
Mm-hmm.
Your nausea is resolved, your jaundice has resolved. Correct.
Mm-hmm.
Juanita Diaz, I believe Ms. Diaz was the first plaintiff who testified in the case. We believe that she had a follow-up visit in January 21, showed significant improvement. There were lab studies, by the end of March 2021, they were even lower. She's not treated with the gastroenterologist. No follow-up currently scheduled. No future care. No plans with the hepatologist. And most importantly, she's able to do the same activity she did prior to her injuries. This is 1 minute and 35 seconds confirming those facts and others. Go ahead, Rob.
As part of your recovery, is it correct that the doctors ever told you you're going to do liver treatment?
Except for the doubt in the hospital, no, nobody told me that there was.
In fact, you were never transferred to a transplant facility.
No.
So you at no point you were ever placed on a transplant list. Did you ever see some psychological treatment after your illness in November of 2020, correct?
That is correct.
And that's the place you would have gracefully gone to May or June of that same year, correct?
Yes.
So approximately 4 months.
Yes.
Now, as it relates to this psychological treatment that you received, you didn't see any anti-anxiety medication, did you?
No, I did not.
And you don't currently have any plans to see a mental health provider, do you?
Yes and no. So I'd like to maybe connect with somebody that can help me get stronger, but I'm busy. I haven't really taken the time to look for the right person. I listen to an audible, I try to, talk to myself a lot, but I probably can benefit from professional help if I go on that for one.
Right, but as you said, again, you don't have no plans to get something in the future.
And then we talked to a retained medical expert about that subject matter.
Then we go on to Juanita Diaz, liver failure. Go to page 8 of your report. On March 21, 2021, they did the liver enzymes. I know I'm sure what her AST was. It's about 4 full paragraphs.
19 and 14. Based on the drug, did you form any opinion as it relates to Ms. Diaz's drug use?
Because of the fatty change and the clinical picture and the inflammation that I saw, I would say that this is consistent with a drug-induced liver injury because other etiologies, other causes of liver injury were ruled out. I didn't see any significant scarring, and I didn't see any evidence of long-term liver damage.
What is the long-term outlook?
Diaz's liver tests came back normal. A few months later, complete absence of abnormalities of liver function tests. She didn't have significant fibrosis on the biopsy. And she had a FibroSure test, which is these 6 chemicals, and that was normal. And her symptoms resolved, and there's no evidence of chronic liver injury. Her prognosis is excellent. Ms. Chang? She was admitted to the hospital in November 2020, discharged November 2020. She had improved, and in November she was asymptomatic. No testing currently, no symptoms since her hospitalization, no future care from treating providers. It's 1 minute and 42 seconds.
And so as you're seeing this in earnest, has your treatment physician recommended any additional treatments as a result of the water incident?
No.
And so as you sit here today, you're not taking any medication specifically for the water incident?
For real water? No.
You haven't handled, there was a lot of talk about liver transplants, you haven't had liver transplant, right?
No.
Yeah, there's been no recommendation for liver transplant?
No.
There's been no discussion of possible liver transplants in the future?
No.
From what I saw in the medical records, you're not going through any routine monitoring other than what you specifically request these liver being done, right?
I mean, I have monitoring for other issues that I've had over the years, but not specifically for what I was in the hospital for.
And that's why when we started this, I just wanted to be very clear that I'm not asking for other conditions. I just want to make sure we're talking about real water here. So again, no routine monitoring with regards to anything that fellowship is doing for the vehicle. And you're not actually claiming any psychological machinery as a result of consuming for water, right?
No.
And as you sit here today, and this is my last question, Mrs. Chang, no treating physician, any of your treating physicians, has recommended any additional care as a result of you consuming real water as a natural.
Yeah. 100%.
Do you think that's very good?
Of course, if for anybody, that will be good, yeah.
Thank you very much for your time, Mrs. Chang. I
Thank you.
appreciate you.
Mr. Nigel Davis Richard was discharged from the hospital on December 2nd, improved over several days. There's one follow-up on January 6th. All the symptoms have improved. Go to the next one, please. Mr. Richard, no longer experiencing any symptoms related to his liver. Last treated was 4 years ago. No treating provider recommended future treatment. No relapse or flare-up since last treatment. No longer on any medications. No limitations to his day-to-day life. Mr. Richard's testimony.
Do you have any continuing medical conditions that you attribute to the water escape?
No, but I do go to my primary and I get my liver checked with my labs. So that's the only thing.
At the time of your deposition in October of 2024, you were not aware of any ongoing liver issues, correct?
No.
No. That's not correct, or there not having any ongoing liver issues?
No ongoing liver issues.
And you aren't on any medications to treat you, correct?
No medication.
And you haven't had any treatment or counseling with a psychologist or a counselor?
No, I do have a counselor, but no, not
Not related to this?
No, not at all.
In the doctors that treat you, including your primary care physician, none of them have told you you need any future treatment related to your illness?
No.
In your deposition, I think you also testified that there are not any activities that you used to perform that you cannot perform today. Is that correct?
Yes. No, I don't.
And in your follow-up treatments with your primary care physician, you have any liver issues?
No.
You can see various folks responded to it differently and had different injuries and recoveries. In this particular case, this young man testified quite well on the stand, Mr. Richards, about what he had gone through when he was at the hospital, and even the support of his partner, etc. He had not seen a psychologist, etc., or a counselor for this issue, but he did see Dr. Sam.
Continue on. Thank you for indulging me. Anyway, so the PTSD, he's saying that there are some symptoms. Doesn't mean he's saying I don't have any symptoms, but it did not cross the aggregate number threshold.
For a diagnosis for PTSD. Mr. Delmore, remember him quite well. He stated at the beginning of the trial, he was admitted to the hospital on June 14, 2018 for several days, testified at length the struggles that he had, waking up, couldn't move, had to call his landlord, very concerned, had to pull himself up, go to the restroom, etc., not denying that. Also not denying that he was discharged by July 6, 2018. His symptoms had resolved. And we also can't deny he admitted feeling better the next day, so much so that he checked himself out of the hospital. All right. So there's a lot of talk about how they put him on the death ward, and he had to go scrounge for cranberry juice, and that the nurse took him under his wing. Despite all of that, the real evidence is he checked himself out of the hospital. And we've got a 1-minute clip of his testimony.
No, sir, no, I've never sought psychiatric or psychological services in any department.
Other than all this,
I'm not, no.
have you talked to any medical professional that could possibly assist you with whether or not your water changed your taste of music or caused a delay in cruising?
I have not, sir.
Is there a reason why you chose not to go try and get those opinions?
I can't give you one, no.
And so, more broadly, I guess that means that you're not really treating right now for any of those symptoms that were associated with real water in 2018, correct?
That's correct, sir.
So speaking of which, were you aware that your language abilities came back within the average range during Dr. Stan's test?
Happy to hear that. Yes, I pride myself in my vocabulary, yes, absolutely.
And that your cognitive abilities were well within the average range?
Right. That's good news. I didn't know that.
Let me stop there. That was unsolicited. Go ahead.
All right.
Oh, stop a second. I'm sorry. We don't need to go. Can you pick it up from there? Robin?
That's the end of the video.
Oh, okay, cool. All right. Also, we had Dr. Hudson commented on Mr. Delmar. Go ahead, please.
All right. He was seen on a July 6, 2018 by his primary care clinic. That's on page 7. You see that?
Yes, yes.
All right. And it says that on July 6, 2018, his symptoms had resolved, correct?
Correct.
What was his AST?
37?
All right. We'll move on to Mr. Mano. Mr. Mano is married to Ms. Chang, was testified very straightforward about what his conditions were. We had stated in our opening that he was discharged in December. It was over 4 years ago. Oops, is that all we have now? Okay, you're right. Non-viral hepatitis was resolved by his own admission. Current labs were normal, symptoms resolved. One-time follow-up in February 2021. Time flies. No relapse or flare-up since last treatment. No plans for future treatment. No longer on any medications. No treating provider advised he'll have long-term problems. Is able to do all the things he could do prior to his injuries. No change in pre-illness recreational activities. The fact that Mr. Mano had, by his own admission, a very good recovery, we're not saying he wasn't injured. We're not saying he's not entitled to compensation. We're not saying that someone got their life together and got back and became productive. We're not punishing him for that. But it has to be considered when we're talking about the damages, right? Not the same as everyone's. We've got a minute 30 on him.
It says if you are comfortable with that plan, you agree to be discharged. And as we sit here today, you don't have any current future treatment plans, no. And you're not a transplant that's currently approved. Has any physician told you that you're going to need longer treatment?
No, just for the hospital, possible.
Right. And you're not currently taking any prescription medication, right?
No.
Well, as you sit here today, you can perform all the same activities now that you were able to perform before you got sick, correct?
Correct.
And you do not need any outside assistance to perform any of the tasks that you were able to perform by before your recreational activities haven't changed since before you got sick? And you haven't received any mental health treatment from the time you got sick to today, correct?
Correct.
So just to summarize, no relapsing symptoms since November of 2020. True? Sorry, December.
Correct.
No liver transplant recommendation?
No.
No current treatment? No medications?
No medication.
No physical limitations?
Now, does that mean that there's no damages associated with him seeing the love of his life laying in bed? No. Does it mean that he wasn't harmed mentally when he told his daughter that he was dead and carrying on? No. We've never said that. But when we talk about damages and future damages, we also have to factor in this information, right? Because this is a case about damages, and we have to see how people recover. He was checked for PTSD as well.
Gary saying his PTSD symptoms don't cross the threshold for diagnosis. He did fine on other areas of cognition with the exception of his attention.
Let's move on to Mr. Mano, who had an acute liver injury. Where I want to go is page 10. He did a follow-up with St. Rose Community Hospital on December 23, 2020. Correct?
Correct.
And an ALT of
16.
very normal, correct?
Correct.
He was discharged and improved condition, correct?
Correct.
Lynn Morris. See Mr. Morris here today. Mr. Morris also testified about how it impacted him. You may recall he underwent testing at UMC for the cause of liver injury, including viral, infectious, autoimmune, and metabolic testing. Well, he ain't drinking real water. So all the tests were negative. That doesn't mean he wasn't injured. Doesn't mean that he didn't suffer. This is an individual who had pre-existing PTSD, had been in the service, and it stated that he had been stationed somewhere where, I don't remember what it was kind of frightening, where they were having incoming, you know, what is it, bombs and stuff coming in, 1 to 20 a day. Yet he says this was the most stressful thing he's ever had. You'll have to gauge that credibility. But he testified here that he was discharged with no further care. Also with Mr. Morris, says his stomach is upset on occasion, takes a pill, make it go away. And he's the only one in his house, got sick for drinking real water. There's a clip for him, it's only a minute.
As a result of those tests, no doctor recommended liver transplant. In 2026,
No, no doctor did.
no doctor recommended any kind of surgery as a result of those lab tests.
That is correct.
And my understanding is you had a CT scan done in May of 2020, is that also correct?
Probably.
Do you recall the results of that CT scan?
No.
See where it says the liver is grossly unremarkable?
Yes.
Do you recall doing psychiatric testing from Dr. Sands to specify this?
Yes, sir.
Do you recall Dr. Sands finding that your language abilities were within the average range?
Sounds about right to me.
Your cognitive abilities were within the average range?
Sounds about right.
Do you recall your executive functioning abilities being within the range?
Sounds about right to me.
Ms. Nally, I believe she is Ms. Van Buren's mother. Acceptance society after being discharged, all familiar, like we said. Required no routine monitoring, required no follow-up visits with their healthcare providers. June, told that her liver was, quote, not having problems. No routine monitoring of her liver, no follow-up scheduled in 2 years. This clip's a minute and 50 seconds.
In regards to liver function being normal, yes.
So, let's go, so PTSD within normal limits, cognitive impairment within normal limits, we talked about that, right?
Yes.
And then Dr. Sands is giving you a clean bill of health as to the variety of different potential personality problems as well, correct?
Evidently.
Okay. And overall, this is pretty consistent.
It is.
How many visits have you made to a psychiatrist or a psychologist since your discharge?
None that I can think of.
And so for the past 5 years, you elected not to go see psychological or psychiatrist?
Yeah, I guess that's true. I guess I was really more focusing on my kid.
You got an liver transplant?
No, I haven't.
You know doctors?
No.
You haven't had any surgeries as a result of that?
No.
You haven't had any routine monitoring done beyond the blood tests that you had or Kaiser, let's just say Kaiser.
Right.
No routine monitoring outside of those 3 visits to Kaiser, correct?
Yeah.
And those routine visits came back with normal liver enzymes and normal liver function.
Correct.
No doctor has told you, aside from the retained experts in this case, that you'll need additional medical treatment going forward, correct?
Not in regards to liver function.
Abraham Olvera, that man we discussed earlier. Had to be scary for him. I think he was 15 years old when this incident happened. Checked into the hospital on November 6, 2020. Discharged 3 days later with liver injury tests rapidly improving. Had 1 follow-up visit in November of 2020. Most recent clinic note of that December 2020 reports that his liver enzymes were normal. He made a full recovery with no apparent long-term complications. You also may recall Ms. Olvera also had some testing done with Dr. Sands, and when it came to his MMPI, provided so little effort as to completely invalidate that test. There's a clip on Ms. Olvera.
And
2
on the
minutes.
last day in the hospital, when you woke up, you felt normal again?
Correct.
This is a discharge record. Down at the bottom, All that's improving, patient at baseline, tolerating a regular diet, up and out of bed. Is that how you call your last day in hospital? Getting up and walking around, getting a little crazy.
Yes.
Back to baseline. You know what baseline is?
No, I don't.
You think it means back to the health you were before you got ill in the hospital?
Yes, somewhat correct.
Okay, so this was another visit you had, and this is, my understanding, the last doctor visit you've gone to. Down at the bottom, under assessment plan, it says LFTs, liver function tests, are now normal and plaintiff is asymptomatic. Mother states he has no other complaints. Is that accurate about that time?
Yes, it is.
That's where you have, my understanding that's the last time you've gone to a doctor for anything, is that correct?
That's correct.
You haven't gone to any medical provider or hospital yet?
No.
So the last time you saw a doctor for any reason was December of 2020?
Yeah, that's what I could record, yeah.
You haven't had any medical monitoring or treatment whatsoever in the last 3 years, is that correct?
That's correct.
You haven't had any doctors, no follow-up visits,
No.
no medical monitoring,
No.
no psychological counseling?
No.
Do we have a clip after this? Kathleen Gacias, the plaintiff's experts ignored her totally. Claiming indigestion. Not sure why she's in our case based on the lack of medical documentation, records, psychological care, etc. But she testified, and she was also helpful in understanding her mom, Ms. Strong's health issues.
Did you see a doctor about these problems you had? You were trying to get not agree. Is it true that when you were in town there in October, your mom had an unrelated real water health episode that caused her hospitalization?
Yes.
And wasn't it true that subsequent, when she returned to California, she had unrelated real water medical condition that caused her to have hospitalization?
Yes.
The issue that ended up her being in the hospital, that was not related.
Yes.
We were able to have a conversation with her to discuss it.
Yes. She was having fatigue and fatigue and a lot of the symptoms that she was having around Halloween.
That hospitalization had to do with Dr. Hudson.
I've not met him. No.
Do you know Dr. Singh?
I have not met him.
So the only doctor that you can recall seeing who was related to this was the 2021 year.
Yes.
Again, not all claims are the same. Mom, Carolyn Strong. Very similar, liver enzymes back to normal. She continues to get checked every 6 months. Excellent long-term outlook, supported by normalization liver function test, absence of significant fibrosis on biopsy. Remember, she had a biopsy. Resolution of all clinical symptoms, no evidence of chronic liver injury. Here's her testimony. It's 1 minute and 10 seconds.
Counsel asked you if you are committed to following with recommendations. So that's yes. What were the recommendations that you're committed to follow?
Cognitive
care, evaluation.
And how far have you gone along?
Well, I haven't seen anything yet.
You haven't been committed enough, at least up to this point, to follow those recommendations, correct?
I haven't done yet.
Good thought about it. You know of any medical doctors who will be testifying on your behalf related to your procedure?
No.
But you would agree that you're getting better, you're feeling, more normal.
Correct.
We're 4 years out, it's not true that your liver enzymes by your own testimony got back.
Yes, correct.
So other than the memory part that you threw off the brain fog, everything is okay, isn't it?
Physically.
Well, mentally, you haven't gone to see the mental healthcare professionals, correct?
No.
That's her case. Our shift gears and talk about Ms. Bonnar. Ms. Bonnar has been diagnosed as having autoimmune hepatitis. Her last drink of the water was in 2018, but her condition improved and she was discharged. April 13, 2018, her AST, ALT levels were normal. Through her deposition, she was working full-time, Monday through Friday, 7:30 a.m. to 4 p.m. with no difficulty. That means she's not injured? Does that mean she's not entitled to compensation? Of course not. But it established for your consideration future care and needs, and she's working full-time. She has anxiety, but not all of it related to real water. She's on medication, not related to real water. As far as she knows, she has no ongoing issues with her liver. Ms. Bonnar is an outstanding person, based upon the evidence. She had to go to a number of hospitals, and I lost track. I don't know, there's 7 hospitals. She had to be flight for life out. That's traumatic. We're not denying it. This is her recovery. That's to be applauded. One of the comments, however, was that Ms. Bonnar, since she has autoimmune hepatitis, that it's not clear whether or not that she'll have relapses. It's a possibility. It could happen. And one of the arguments that's been made is, well, she hasn't had a biopsy to rule that out. Ladies and gentlemen, you understand that's not our burden for someone to get a biopsy. That's the burden of proof for plaintiffs. And I understand no one wants to get a biopsy, despite Dr. Hudson's description that it was really nothing to have one. But we don't have any control over it. But we do know that based upon her treating doctors, which is important, none of them have apparently stated, based upon her current medical condition, that a biopsy is warranted. That's important to consider. We have some clips on this. I believe that she may have seen Dr. Sands. I'm sorry. That's what I just said.
Do you remember being interviewed by a doctor?
Yes.
Did you ever give any recommendations to you after your examination?
Yes.
But you did not follow those recommendations then?
I haven't had a chance to. I've been focused on myself.
Did you prescribe anxiety medication as well?
Yes.
When the counsel was talking to you about any issues you had with your liver since, you're saying that that hasn't happened since what year?
2021.
Thank you. Now, again, let's slow down. and talk about plaintiff's experts on this board and May. We had Dr. Hudson, Manfred. Neither one of these are treating doctors. Normal, proving, Sands, whatever this is worth to you guys in terms, she tested for it. Motor functioning, executive functioning, which is key in her job, is normal. There was, in closing argument, an argument made, well, there's an article out there that she's going to have relapses every 4 years. Okay? No doctor has said that. That's an article. Doctors testify within a reasonable degree of medical probability. And that is consistent with her treatment. Dr. Hudson also had things to say about Ms. Boardman.
According to your report, she went there to make sure that she was symptomatically improving. Is that accurate?
That is right.
And when they did a study on April 13, 2018, a month later, mind telling during what her AST was?
AST was 28, ALT 43, alkaline phosphatase 88, total bilirubin 0.9.
All right, AST 28 is the normal between 8 and 48.
Correct.
ALT is 43, normal is 7 to 55.
Correct.
Let's talk about the organ. The fine motor function is normal, also executive function.
Now, what's interesting about Dr. Hudson, he's also opined that, based upon his research, that hydrazine in the water can trigger autoimmune hepatitis reactions. And he testified to that on the stand. Go ahead, please.
Question, can you tell me a single study of anyone who supports your theory that hydrazine could be a trigger, as you described it, for autoimmune hepatitis? Answer, nobody in the past, but I'm going to publish it. Answer, right. You could get some notoriety out of this case, right?
Absolutely, as I was joking.
So this is when Dr. Hudson was asked about that. He gave a different answer. We call it impeachment. We read his deposition to him, and he said, yeah, I did say absolutely. I was joking. You make the determination.
And can you tell me of a single study of anyone that would support your theory that hydrazine would be a trigger, as you describe it, for autoimmune hepatitis?
Nobody in the past, but I'm going to publish it.
Right? You could get some notoriety out of this case, right?
Absolutely.
Must have been an inside joke. That's their expert. And when I say their, I mean the plaintiffs. Attorneys are not parties to this case. Lisa King, an incredible person. According to her experts, she needs to have follow-up visits with hematologists and neurologists. We don't deny it. She also suffers from this condition. I'd never heard of it before this case. It's terrible. Don't deny that. To her credit, and what credit she should have a strong family. It's not impacted her ability to work in the context of performing her duties or prevent her from traveling. She's living her life. That's not to be held against her. That's not to suggest she's not injured. We've agreed it. We've agreed that she needs $12 million in future care. We've agreed that she needs to have care for PTSD once it's established. Lisa King, she drank, anybody who drank real water, it was Ms. King. 2014 through 2019. And when she got sick in August of 2019, she stopped drinking. She continued to work and travel, as I stated. She didn't go see a psychiatrist or psychologist. She worked. She had obligations. She looked after her family.
So I've been with the company since 2017.
Okay. And you've been able to do it, sounds like you do it very well. Is that fair?
Okay. Yes,
And you're able to fully, completely handle your duties, correct?
yes,
And in fact, I think you stated at the beginning that you're the top person in your field, is that correct?
I'm the top person in my company, yes.
In any of your treating positions that are supposed to do it.
Yeah.
First time you received an ID treatment,
June 2019.
and then we'll sandwich it in. On the other side, the last time you received it was sometime in February of last month. Last month?
Yes.
What I have is next month is February of 23.
Correct, I had 2 days back to back.
All right, and then March of 23.
Correct.
And then April.
Correct.
And then there was a break until November. Is that it?
Yes.
If you had one in November of 23, and you had one in February of 25, you had any,
I did not.
so that's about 13, 14 months.
Yes.
You started experiencing your health issues in 2018, is that accurate?
Yes.
During that period of time, you were able to travel to San Juan, Puerto Rico,
Yes.
and Budapest, Hungary.
Yes, that was 2018.
I thought it was in January 2019.
I went there actually for New Year's Eve, so there might have been a day or two lapse in January.
For a long and consistent cough that was resolved as well back in 2018, correct?
Yes.
In your deposition, I'll represent you. The question was, when was the last time you had any sort of speech? You said, I believe it was sometime.
That's probably correct.
All right, Ms. King was able to function, able to work, able to travel. She was able to live her life the best as she could. We're not taking credit for that. That's on her. She did it. We're not saying that her damages are lessened due to the fact that she made the best of a situation that was foisted upon her. We're not. Don't you ever get that impression. No one is disputing her fortitude or her character, or anybody in this case. We are going to have a dispute as related to future care, as related to psychological care. And we'll get in that when we break down what we feel the damages are. Which, ladies and gentlemen, starts with the plaintiff's retained experts, because that in large part is what they're relying upon to establish damages. Their collective experts are Sands, that's the psych guy. Hudson, we've met him. Let's get notoriety. We got Najim, PhD. I think he came up with some ideas on how hydrogen got in the water, if I'm not mistaken. I could be, but I don't think so. Ms. Hutt, she was super interesting witness that got up there. She had the expertise in quality care and had strong ideas about how wrong Real Water did their, how they operated. And Ryan Dadnow. He is the guy from South Africa. He is the pathologist, the person who looks at the slides. They have other experts, but we believe that based on the evidence presented, those are the most important. So when you deal with damages, you got to look at the experts, see what they have to say. Start with Sands. You already know the background. Got 12, saw 13 of the plaintiffs, of course not Ms. Casillas. I told you what was going to happen on this one, right? One size fits all. Doesn't matter if you're a young person or an older person. Doesn't matter if you have liver injury, you have liver failure. It doesn't matter if you have autoimmune hepatitis. It doesn't matter if you have mastitis gravis. It doesn't matter the timing of the exposure or how long the exposure occurred. It doesn't matter if they claim psychological injury or not, or what their actual injuries were. He gave a not pejorative, descriptive, cookie cutter opinion on what everyone should have in terms of psychological care. and we maybe beat it into the ground, but it bears repeating, is that keep in mind, Dr. Sands admitted those are his recommendations, but each of these individuals that he saw, whether in person or remotely, they had to go see somebody first. They had to go see a psychiatrist or a psychologist or a mental health care professional, get assessed, and then get treatment. So his opinion that on average he thinks it's going to take 4 years and it's going to be $120,000, he admits, but I don't know. They have to be assessed, which is why we had to ask those people, why do you keep asking them about their psych care? Well, because we're establishing they didn't do it. And that goes a long way for y'all to determine future care as related to psychological counseling. Ladies and gentlemen, I'm talking, we're 4 years out. Nobody has taken Sands up on his recommendation. And when I say 4 years out from the injury, his recommendation came a few years ago. I don't want to misstate that. But they haven't. That would suggest to you they don't need it, or I don't think it's important enough to do. But you don't come into court and say, I was busy, I was thinking about my kid, I haven't gotten around with it, because that's inconsistent with that claim. But that was Sands. Sands admits this with the crystal ball testimony.
And I want to provide that opportunity as a recommendation for them for a period of up to 40 years. Some people might need 5 years, some people might need 2 or 3. I don't have a crystal ball.
That's very good. Outcome will vary based upon the evaluation as it relates to each of the practice. Correct?
As it should be, yes. Correct, that's my recommendation, yes.
Some of those people may not be in health, correct?
Not likely, but yes.
And it would vary plaintiff to plaintiff based upon what these other professionals come up with in terms of treatment.
Sounds correct.
And I might add, Dr. Sands never said anybody needed a lifetime care for psychological injuries, much less someone who went and actually saw a psychiatrist, a psychologist making that recommendation. Move on to jury instructions. You got to rely upon the credibility and believability of witnesses, fears and motives. And if you believe a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of the testimony which is not proved by the evidence that applies to all witnesses, both fact and expert. Let's talk about that expert, Dr. Hudson. As we stated, he's another non-retaining expert, does not have a doctor-patient relationship with any of the plaintiffs. Testified last month, that none of the plaintiffs in this case have a definitive evidence of scarring on their livers. Now that's important because you prepare for a trial. Well, this is their expert, their liver guy, right? Says there's no definitive evidence of scarring on their livers. If a person suffers from hydrazine-induced liver injury, they have a 0% chance of relapse once they stop taking the hydrazine and his depositions. They have acute liver failure. It's different than acute liver injury. 90% of the people recover fully. Now, don't get me wrong, the 10%, that's a bad one because they either die or they get a liver transplant. Okay? As we know, none of our folks fall into that 10%. So that's what he's testified to. And then he admits he wants notoriety out of the case. No joke. So you have to look at his opinions carefully, because that deposition was taken on January 10, 2025. No irreversible scarring in plaintiffs. Short 2 months later, guess what he finds? Irreversible scarring in plaintiffs. Diametrically opposed opinions within 60 days of a doctor, a retained expert who testifies under oath, can make any changes he wants after the fact, to his deposition, but does not. So this is what we're relying upon, and when I say we, defendants, we're relying upon this, and then we get this. Dr. Hudson received no new medical records for any of the plaintiffs during this 2-month period of time. That is a critical error. That isn't, I thought it happened on Tuesday, it happened on Wednesday, I thought I was wearing yellow, I was wearing red, I got married in 1982, but now I really got married in 1983. No, that's the whole crux of his testimony, one would think. So we questioned him on it.
Question, all right, is there any irreversible scarring in any of the cases you're handling in this matter? Answer, there has not. Was that your answer, sir?
That was my answer.
All right, so let me read the question again, see if it's confusing to you. Is there any irreversible scarring in any of the cases you're handling in this matter? And you stated under oath 60 days ago, there has not. Correct?
Correct.
Pretty darn clear. Ladies and gentlemen, I've made mistakes in this case. I thought that Ms. King had been to China. She had not. That was her husband. There's a lot of facts to go through. So this isn't a pejorative fact. We believe the plaintiffs made a mistake regarding Dr. Hudson's opinion on several plaintiffs and using the term acute liver injury. Counselor Kemp said, and Dr. Hudson agreed that Abraham Olvera had acute liver failure. And J.J. Delmar diagnosed with acute liver failure. These terms are not interchangeable with acute liver injury, according to Dr. Hudson. Here's what Dr. Hudson actually said about plaintiffs. And remember, this is when we're breaking down who had injury versus who had failure. People that had failure, it's more significant. People that have injury, less so. Mortenay, Delmar, Mano, Morris, and Olvera. You don't take my word for it.
I want to talk about each of the you identified the following plaintiffs of having acute liver, whether we can call that ALI, acute liver. That is Ms. Mortenay, Jake Delmar, Chris Mano, Glenn Morris, Abraham Olvera. Is that bad?
That's correct.
There's a difference.
And you know there's a difference between the two. And, you know, you get doctors of specialty. We had Dr. Lynn, who is a...
Correct.
Sorry.
There is.
Okay. Dr. Lynn, who's the pediatric liver guy, Miguel Memory testified remotely. He agrees with Dr. Hudson as related to Mr. Olvera. Okay, so in this case, Mr. Olvera had a liver injury, but did not have liver failure. Yes, sir. In review the records, as well as you mentioned, Dr. Hudson's testimony, he had acute liver injury. Let's move on to Dr. Datnow. Datnow, gentleman from South Africa. I only say that because it makes it easier to remember his accent. He talked about this deal, a Batts Ludwig scoring system. I don't know if y'all followed that. It was put up on the board a couple of times. So chart where they stage the various issues of fibrosis on the liver. Say 0, none, 1, portal fibrosis, mild, 2, moderate, 3, severe. And as y'all know, what is the serious one that you recover from? Cirrhosis, 4. Can't fix it once you're at cirrhosis, meaning the body can't, the magic liver, the beautiful liver. So he was going to talk about looking at slides of various folks. 2 people, I believe it was Ms. Strong and Ms. Diaz, is that correct? And then he looked at a third slide of someone again who's not in this case. Someone who's not in this case that the slide showed all sorts of -3 and perhaps even 4 levels. But when you broke it down to, let's talk about our case, that would be refreshing. he had a number of opinions. Go back, please. Oops. Maybe I'll stop doing this and you do that. There you go. He testified, check it, at least a grade 3 on Diaz. But it's cut off, so I can't see what's on the other side. So maybe it's a 3 or a 4. You can't see it, so it's a 4. 3, maybe a 4. Then later. So I can say this is at least a 2. And may be a grade 3, or it's a grade 3 and possibly a 4. This is their expert, right? What can we make of that? And it's possibly, I can't prove it. I would say 3, yeah. So I guess he settled in on a 3. And going back, 3 is pretty hardcore. That's severe fibrosis. So again, his deposition was taken. And this is what we got.
Let's move on to Vanya Diaz. Now, you reviewed 7 slides in that particular case as well, correct? Correct. And you reviewed those slides and came up with microscopic findings as well, correct? Correct. And you found there was minimal to mild portal, sinusoidal, and paracellular fibrosis, correct? Correct. And the VATS blood fluid grade that goes 1 through 4, your grade was a 1. Yes. Wasn't a 2, wasn't a 3. Correct? Correct. And in fact, as it related to Ms. Diaz, your final pathological evaluation showed resolving acute hepatitis. Correct? Correct.
Well, that's what happens when you get put on cross. You're not allowed to run off like he did. He was brought back under control. Then where it ended, he goes on to Ms. Strong. How do you rate her liver scarring? Here we go again. There's at least a stage 1. There's areas that are very reminiscent, whatever that means, of a stage 2, possibly a stage 3. At least he said he didn't see cirrhosis, which we know is a 4. So he settled in, so she's a 1 or a 2, correct. This is someone testifying with a reasonable degree of medical probability? Reminiscent? Possibly? Well, let's just go to your report, sir.
Isn't it true that when it came to Carolyn Strong, your findings were that she had mild periportal and paracellular fibrosis? Correct. And that the VATS blood fluid grade, when it went to 1 through 4, it was a 1. Correct? Correct. There's nothing in your report indicating that she was a 2, a 3, or a 4, was there? No.
All right, so now we've gone through Hudson, we've gone through that now, Peach repeatedly. People make mistakes, I understand it, but we've established what the true damages were. Dr. Najam, he had a couple of theories. They were hypotheses on how hydrazine got into the water. Remember, Mr. Kemp had passed around the titanium tubes. There's a theory that the titanium tubes at some point leached out, not the titanium. Yeah, titanium tubes leached out hydrazine into the water, all of that stuff. That's a problem they've never seen here before. Can't be sure what the problem is. A very interesting guy. Then we talked to Dr. Hutt. Now, Dr. Hutt's testimony I thought was, on the surface, very effective. Basically, Dr. Hutt came in and said, hey, I'm at the top of my game. I work for top companies. That isn't how you run a company. That isn't how you produce water. That isn't how you respond to customer care. That isn't how you test water. And you have a secret room, and you didn't do this, and you do that. It's very strident about it. And that is her job. I mean, she's smart. She understands what the industry is. But she's interesting, other than, she got kind of on a diatribe, if you recall that, but it boiled down to ignoring some of the theories on how hydrazine got into the water to begin with. Because if you remember, hindsight in her world is 20/20. She's saying when the company was started and before any water rolled off of the assembly line, y'all should have done, I forget what the terminology is, I'm sure I'll be corrected, but basically you should have tested that water from Jump Street. It doesn't come out until you tested it for anyone to consume it. right? You're gonna make these representations, it's the healthiest water in the world. You darn better well test it before anyone gets it, all right? Off the end. And she kept talking about that. But if the theory was that the hydrazine got into the water based on a slow breakdown of the titanium tubes, Jump Street's not going to pick up hydrazine, is it? Because it hasn't degraded over time. That was one of the theories. So Ms. Hutt ignored that. She also stated, and it was stated repeatedly, ladies and gentlemen, that Real Water never tested the water. You know that's not accurate. They tested the water as you normally test water. They tested it daily, weekly, whatever that is. The water was tested. But when those reports were brought to her, she said, don't show me that. Y'all didn't check the secret room water, and on and on. Don't show me any test you want, and I won't deny you tested the water, even though it was represented at various times in this case they never did. You didn't test it in that room. Ladies and gentlemen, again, ignores the fact you have to test the water at the end of the process, not in the middle, at the end of the process, and the water was tested. Was it tested for hydrazine? No. But it was tested what they thought they had to test for. So her theory of keep jumping back, you guys are the bad guys, and secret room and all that, it's the only secret room I know where all the employees know what's going on. They had a proprietary process of making alkaline water. That's why it's set up that way. You have to leave the water out because they put ozone in it. That has to settle. So these sort of ad hominem attacks on the water, you can't get it to the homeless, they'll get sick. Bless you. You has to sit. That's the process. That's what has to go on. It's the end product. Tested daily, weekly, monthly, etc. Move on. Magic liver theory. I don't know if this is supposed to be our theory or the plaintiff's theory. But Mr. Kemp stated, you know, magic liver heals itself. But no expert testified to that because it's not true. Okay. Liver doesn't heal itself when you have cirrhosis, but it does heal itself because we go to the illustrious Dr. Hudson. He says the liver is a special organ unlike any other. It can regenerate as long as there's no permanent scarring, almost like one would talk of a lover. It's a wonderful, that's 250 things. That's why I like having it. Cool job. If you love your job, he loves his job. That's what he said. No, we don't know anything about the magic liver. We have to rely upon what the experts say. Don't believe me? Let's listen
Is
to
the
it.
liver a special organ in the human body unlike any other? It is. You bet it is, correct?
Correct.
And how is that? And third, it's the only one that can regenerate.
Correct.
And that's an important factor in your profession, correct?
That is correct.
And when you say regenerate, you mean it can heal itself as long as it's not scarred.
That is right.
All right, let's hit defense experts. Let's start moving it. Robin, he was the guy that came in. He's also the, I get him mixed up, pathologist. It was interesting, if you're boring like myself, he lives like down the street from the other pathologist, remember all that stuff, and he got accused of breaking into his house and all that. Bottom line, he came in and testified that he looked over, to the extent he looked over slides, that he didn't see any ongoing liver injury. But he again agreed to this love of the liver and its amazing regenerative capabilities. Stated that ketosis is not permanent. Go ahead and hit it, I've got a bad remote. Fatty liver and fatty liver disease are reversible. Man, I don't know how many times I heard about fatty liver on this trial. Fibrosis is not permanent. Hit it. Liver can heal from bridging fibrosis. Remember, there's a lot of testimony about bridging fibrosis and all of that. Says it all heals, can recover from drug-induced liver injury. Just And acute liver failure is not a permanent liver injury. Key, acute liver failure is not permanent, according to him. Not attorney argument, that's what he said. Go ahead. Alcina, he's another liver guy, Harvard, general surgery, director of liver transplantation. He's an interesting witness. Needless to say, he had an opinion.
You were asked about possible permanent liver injury. You recall that?
Yes.
In your opinion, any of these 8 plaintiffs, have they suffered a permanent liver injury? More likely than not.
More likely than not, I don't think so. I don't think so.
In any of the 8 plaintiffs that you reviewed in this case, did you identify any evidence of cirrhosis?
None of them. Hepatic necrosis is how the liver responds to the injury. I mean, the cells have to die, and then cells regenerate, and they don't keep dying unless you have some toxin going on continuously, whether it's alcohol or a drug or something.
Is the liver capable of regenerating itself if it's undergone an episode of hepatic necrosis?
Well, all this liver is regenerated to some degree. I mean, they regenerated from their injury and they form new cells. Otherwise, the patients would not have recovered.
Okay. Well, the magic liver theory, I'll take responsibility for that. It's backed up by Harvard dude, and all the liver experts say that. Hudson, everything else. And not to leave anybody out, even the pediatric liver expert opined in. Dr. Lynn, he's who we talked about before. Hepatologist means liver, pediatric, you know what that means. Transfers liver between children. Here's what his thoughts were on. Just a second. Thanks, Robin. Remember, he only saw or looked at Mr. Olvera as he was juvenile. Go ahead. Thank you, Robin.
What are your opinions as to Mr. Olvera's recovery?
I believe he's fully recovered from his acute liver injury, and he's doing quite well. In the records I reviewed, I believe a little over a month later, or not even a month later, his liver numbers had totally normalized.
Dr. Hudson testified that Mr. Olvera has permanent liver injury. What is your opinions on that?
I believe that's speculation.
Is your opinion that more likely than not, Mr. Olvera has no liver scarring or fibrosis?
Yes, sir, that is my opinion. He had an acute liver injury, and while the AST and ALT were elevated, they normalized them within a month, as we reviewed, and there's really no other signs on his exam or his medical records that tell me that he's has any evidence of ongoing liver injury for him, or scar tissue.
Is an injury to a pediatric liver reversible?
In general, a lot of injuries are. What's interesting about the liver is the liver is the only organ that can regenerate and recover. When we talk about permanence of liver injury or function, we're really talking about scar tissue or fibrosis, of which I didn't see any mention of fibrosis in the exams that he's had, and also the clinicians that took care of him really didn't seem to think that that was a concern either, based off of his physical exam.
Dr. Hudson also recommended future medical monitoring. Do you have an opinion on that?
Yes, sir. In general, I mean, I go back to what his own subspecialist said at the time of follow-up, which was no additional follow-up is needed.
All right, and that's important because one of the jury instructions talks about put in Mr. Olvera's how long they think you're going to live. You know, they have those life tables, and he doesn't need any additional care according to his own doctors. Who haven't suggested it. He hasn't gone back, and the fact that Dr. Lynn disagrees with Dr. Hudson's recommendation in that regard. So weigh that evidence carefully. I think it's pretty clear which way that goes. All right, ladies and gentlemen, you ready to hear what we think the case values are? Compensatory damages, let's get to it. Past medical expenses, past and future pain and suffering, future medical expenses. I want to go through the compensatory damages with the permission of the court and counsel, even though we're at 12:30, is it okay to proceed, sir?
How much time?
I think, I do it with time. I think we'll have this be done in less than 30 minutes.
Okay.
I'm no judge if the jury doesn't.
Yes.
All right, let's do it. Yeah, where we're coming from, liver injury, liver failure, brought this up earlier, autoimmune hepatitis with MG, Ms. Strong, and Ms. Casillas. Past medical, we agree to all of these numbers. Okay? So, and I went over this on this little, this is brilliant, by the way, counsel. This thing, I have a little cheat sheet. It hasn't changed, and I'll go over it again. Only thing that did change, that Ms. Keene's number changed from the beginning of the trial. So these numbers are when they went to the hospital and got the care, basically, in large part. You know, Ms. Bordenave and numerous hospitals, Ms. Keene with numerous doctors. Those as an aside, almost all of these, if I'm not mistaken, I'm sure I'll be corrected if I am, relate to when they went to the hospital. And you can kind of see those chunk numbers, and they kind of relate to how long they were in the hospital. And so I'll leave this up for a little bit. A suggestion, you don't have to take it as you know, you just approximate. You know, we've got Ms. Chang, 133,000. Mr. Davis, 121,000. Ms. Diaz, 222,000. Ms. Delmar, 57,000. Ms. Van Buren, 131,000. Mr. Mano, 84. The only one had an even number. And Glenn Morris, 59,000. Ms. Nally, 63,000. Ms. Oliveira, 164,000. Believe those numbers average out to about $115,000. Kind of give you kind of a ballpark. These folks, and I notice we're leaving people out, right? We don't have Ms. King, you know, we don't have Ms. Bordenave up there yet. We don't have Casillas because she didn't have any. We don't have Sean because she didn't have any. But we acknowledge that's owed. Okay? No transplants, no recommendations, no MG, no autoimmune hepatitis, normal liver enzymes. You beat that horse to death, there it is. What do we got next? Let's start with the acute liver injury. All right? Not failure. Those are the four. Delmar, Mano, Morris, and Olvera. It's important for you to remember those, at least from our perspective, because it's how we base what we believe these claims are worth. Follow? You have people who never treated. You have people who don't have any medical records. They're off the board more or less. But the bottom line is, these people had a liver injury, miserable experience. Some folks say they still have issues with it. But the bottom line is, these are the four. We don't make those up. We didn't decide who had a liver injury versus liver failure. That was Hudson. He said it. Those are the four. Then we have acute liver failure. I don't want to be dismissive, but it's a step up. You know, it's more significant than a liver injury. That's Ms. Chang. That was that heartbreaking video of her laying there in bed, her husband trying to get her to go to the hospital. We got Mr. Richard and his very unfortunate experiences while he was there at the hospital, being completely out of it. Ms. Diaz, very articulate. We don't need to, you know exactly. Ms. Van Buren, opera singer, fantastic person, and Cheryl Nally. They had liver failure. And you saw what their medical specials were on that last slide. But this has been carved out, lack of a better word, to say how we're coming up with what we feel the damages are. Liver injury and liver failure. Despite all of that, whether it is an injury or a failure, no ongoing treatment, no routine monitoring or limited, and treating physicians aren't recommending future treatment on all of those groups. So you can understand where we're coming from when we break down what we think these cases have in terms of a suggested value. But you guys are going to make that determination. That's your job. Andre Bordenave, here are her meds. $388,000. Medical specials, that's just a turn away of saying medical bills. She's got $388,000. That needs to be awarded. She's the one who went to all those hospitals and the Flight for Life. Seems to be a pretty reasonable number based on some of those other numbers on what she went through. But she's got autoimmune hepatitis. That's what AIH is. So that's the perspective we're coming from in terms of evaluating her claim. Did we skip one?
Go back.
Yeah, let's skip Ms. King. Much of her damages are established as relate to these specials. She's the only plaintiff, thank goodness, with MG, and I know that's a little solace, but significantly different experience from the other plaintiffs. This is her new number. We've agreed to this number, $905,000 for her past medical care. Going through the nightmare that she had to go through with the injections and all of that. That's her past. We stipulated that she needs to have care in the future to a number that their doctors said that she needed. Remember the nice young man who came in here while the attorneys were fighting? That doctor who treats her for the MG? $12 million. We agreed to that. Let's have future care as it relates to the medical specialists. We have a dispute as it relates to her mental health care, PTSD, but these are numbers that have been established and agreed to. Move on, Ms. Casillas and Ms. Strong. I don't know what to tell you here. We don't have any medical bills. Ms. Strong didn't see Dr. Hudson. That's the liver guy. She went and saw Dr. Sands, the guy who gave the cookie cutter stuff, and she never followed up with it. So she admits she was hospitalized for unrelated conditions. There was a slide saying that she had a level 1 on that score, 1, 0 through 4 and all that. That's what she had. I mean, we got that to go by. Ms. Casillas, super nice lady. I don't know what her medical records are. None have been produced. She said she went to see somebody for anxiety, didn't even know the person's name. I mean, how do you gauge that? And she didn't see Hudson or Sands. So what are we doing with that? That's a 0. There are no past. Nothing has been presented, or futures for that matter. I mean, they can't diagnose themselves and come up with their own medical specials. But they're in this case. All right, let me back out, because now I want to break down what we feel are fair results based upon that. All right. If you ever wanted to listen to me, now is the time. Here's what we think would be a fair compensation for everybody. All right, we've already gone through the past medical specials. Everyone understands that. We've gone through the folks that we've agreed on future medical specials. It's basically related to Ms. King at this point, $12 million. Let's talk about future follow-up. There's been a lot of talk about, well, I have to go get follow-up because I had this liver injury and it's going to cost X amount of dollars. But as you know, no one's really doing that because they don't have the symptoms, which is human nature. But when you create the problem, you're going to have to pay for the problem. If they intend to get, they should get future treatment, checkups, check how the liver enzymes are going. Maybe get everything else checked out while you're doing it. Dr. Hudson stated in his report that it was going to be somewhere between $1,000 and $1,500 to have this done. What was it, 20 years? 20 years of that, okay? Forget all the time that's gone by. 20 years in the future, that's $25,000. Everybody except Gasias and Strong. All right? That's the future care that they would be entitled to if they decide to go get tested, like Dr. Hudson. You have to gauge his credibility, of course, going forward. That's a number. That's a future. Let's talk about future psychological care. Ladies and gentlemen, there's no evidence of that that's been supported, as I stated, because that's based upon what Dr. Sands recommended. But if you're not going to take the time, if they're not going to take the time to go see a healthcare professional, get assessed, and come up with a plan, then Dr. Sands' opinions obviously are meritless. He testified, I don't know, I don't have a crystal ball. They've got to go do that themselves. They may have people who don't need any. They may have people who need 3, maybe people have 5. Wishy-washy possibility, not within a reasonable degree of medical probability, right? They didn't prove that. Now we have an issue as related to Ms. King. Now Ms. King, we agreed, stipulated that after what she's gone through, that's PTSD. And counsel, in his eloquent closing, stated we want to get, she's entitled to compensation for ongoing psychiatric or psychological care for PTSD for the rest of her life. And I believe the slide said per Dr. Sands. What's missing? Dr. Sands never said that. He didn't even say that generally. Never said that she needs psychological care for the rest of her life. What he said is all these people should get it. You need to get treated first and get an assessment. And I believe it would be this number. So they've taken that number that Sands came up with, and it looks like they've extrapolated it out, I think, extrapolated it out for the period of her life. I may be wrong, that seems to be what it is. So we disagree with that because we don't think that the psychological care has been established with a reasonable degree of medical probability at any number, but certainly not the number that was suggested during plaintiff's close. Now, what's interesting is, and you'll have to take my word for it, but you don't have to, nor would I ask you to, if you were to back out what we feel to be the overstatement of what her psychological care is, basically it's like a multiple of 4.7. You know, even if you know, we already understand Sands' number was not supportable, but if you like multiply that like by 4.7, it comes up with what their number was and what they think her future care is. Don't know if I lost y'all on that. The bottom line is we're saying there's no number, but if there was a number, it was Sands, and their number is 4.7 times more than Sands on her future psychological care. All right, that's the theory. So we've applied that factoring, what we feel is an overstated factoring, in our own assessment of all Mrs. King's other claims. The claim in close was she was entitled to $150 million, I believe, and damages. Not 150? What'd you have? Okay.
You're talking about two different things. He's talking about psych, you're talking about pain and suffering.
Yeah, we're talking about pain and suffering, 150. That's okay. Remember, pain and suffering was 150. I know it wasn't 150 million for her care. It was like 600,000, something like that. $150 million pain and suffering. So remember, we're advocates here, and if we follow along with this math area, we're not that far apart. All right, here's what we believe based upon all of that. We talked about past, future, etc. We haven't left anything out of believe, pain and suffering. People who had liver injury cover all the money that I stated and $500,000, $500,000, hospital stay, medical care is picked up, you're doing better now, $500,000. If you had liver failure, the step up, there is a medical connection between the level of severity from failure down to injury, $1 million. Now keep in mind, these individuals are not Ms. King or Ms. Bordenave, and they're certainly not Ms. Casillas and Ms. Strong. But as the people who had the injury, you get entitled to recover your medical specials, what you've proven in terms of your futures, which we don't believe they have, other than the monitoring, $1 million on a recovery. Then we go to Ms. Bordenay. All of these individuals are wonderful people. They didn't deserve to be where they are. And when you start putting numbers on people, it's very dehumanizing, but that's what we're here for. That's how we compensate people. Ms. Bordenay, $2 million for the nightmare that she went through of going hospital, 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 before finally finding a doctor who said, hey, here's what the issue is, and she recovered. But she has autoimmune hepatitis. She has to be particularly careful, and she has to go back and get checked. And she may have flare-ups. I believe her last flare-up was 2021, something like that. Remember, she had the initial condition in 2018. I believe Mr. Parker stated, however, that her future should be based upon, well, she's going to have a flare-up every 4 years, so we need to give her hospital bills of $388,000 by some multiple. That's completely unsupported by any of the medical opinions in this case. But needless to say, that's significant. She got autoimmune hepatitis. $5 million in the future. Because it jibes with someone who had autoimmune, someone who went to the hospital, got better, and hopefully remains well. Then we get to Ms. King. Look at the numbers that were put up on the board by Mr. Eglett, and I'm going to use the factor of factoring down from what they had on the future care for psychological counseling. $10 million past pain and suffering. No joke what she went through. And she has to continue to go through it into the future, her life. It impacts her. It impacts her family. $25 million in future. 10 and 25. But it's based upon actual numbers. It's not plucked out of the sky because it's in line with all the other folks. One of the brilliant arguments that some counsel in this matter picked up was, well, Blaine Jones said it was for $10 million. It's got to start then. You remember that testimony? That's the baseline. You remember Blaine Jones didn't say his case was for $10 million. Mr. Kemp said it. Says you wouldn't take $10 million to go through that business again. You know, the dude who was living in a tent and got sick and then came down and had to walk from the hospital. And he took his deposition. He did something. What's it when you go online and try to get people to give you money? He's reading from that. Y'all know what I'm talking about? You remember his testimony? He says, you wouldn't take $10 million to do that again. He said, no, I wouldn't. Well, why don't you assess him for $1 billion, $1 trillion? That's not an assessment of what the value is. Blaine Jones didn't state what the value of his case was. It's a figure of speech. You wouldn't do that again for $1 million, right? How about let's focus on the facts, the meds, the doctor's opinions, what people actually said in testimony. Does that insult your intelligence? Let's see what Blaine Jones thinks the cases were. You guys are the ones who decide that, which gets to punitive damages. Punitive damages are not awarded simply because the company makes a mistake. Oppression means despicable conduct, subjects a person to cruel and unjust hardship. Implied malice means despicable conduct engaged with a conscious disregard of the right of safety of others. The finding of conscious disregard requires conduct that exceeded more mere recklessness or gross negligence. Next, punitive damages are not awarded simply because the plaintiff made a mistake. Why? Because Real Water routinely tested its water, including the concentrate. Real Water was passing the NSF audits. Real Water utilized the HACCP SOPs and employing the HACCP personnel. They weren't perfect. They kept having to hire people. They would fail tests. They were making the effort. Real Water was utilizing multiple water filtration systems. Real Water was using a safe and tested water source. I don't know if Lake Mead counts, but that's where it comes from, and then it gets treated. That's what they're doing. These aren't some shady dudes in the back alley, you know, doing crazy stuff and putting it out to the public. They're drinking this stuff all the way through. Go to the next one, please. Listen to
Like
me.
you described in very, very general terms, what this is a letter from 2017. What is this?
This is a letter from Silver State Analytical Laboratories here in the Vegas area, who the company used to do various testing, and as a third-party certified lab to do the testing.
And what were they testing?
The product, Bonnar.
The finished product?
Finished product, yeah.
How often were they doing testing?
They would do weekly testing, quarterly testing, yearly testing, and then another more comprehensive test every 4 years.
Do you recall that one of the questions that the auditors had was that the HACCP-trained employee had just left the company?
Yes.
What do you recall about that?
So we had, the company had an employee that was working, that was HACCP trained. She had been with the company for 4 or 5 years, I want to say, over the production area as well as quality control. And she resigned her position a few days prior to the audit. It's a surprise audit, you never know what the person's going to come in to actually do the audit. She resigned within a week of when the auditor showed up. So it was a bit of a surprise at the time. And unfortunately, I had to kind of step in and, you know, maybe do the best that I could.
And at the time of the audit, or after that audit, did you take HACCP training?
I did, yep.
Clear and convincing evidence. Judge already stated on the bench what that is. Not going to read it to you, but it's a different level of evidence. No, it's not preponderance. Somewhere in between preponderance and beyond a reasonable doubt that you'd have in a criminal case. As you look at that, because the evidence, you can come in and talk about the 4 things. Well, he didn't do customer complaint. Okay, people saying they were getting sick, they're running the test. They're not showing anything showing up that would make them sick. They're not testing for hydrazine. You're a bad company. Well, no one knows to check for that, right? We're drinking it, etc. Well, we can't help that. Your limited intelligence would have you drinking something that made you sick. That's not to blame us. You understand? That's being negligent, right? That's not trying to hurt somebody or knowing and being malicious, things of that nature, which is what you need for punitive damages as you review the instructions. You have to look at the facts of the case as a whole. You have to look at the company. You have to consider the testing that was in place, considering the efforts to be compliant, consider the actions of the folks who are operating the company, who drank the water, consider the employees and what they were doing. You have to consider folks complain about a product and how you're supposed to follow up with that. You have to claim that real water would have known by, they keep saying, well, you should have known by October of 2020, and therefore you're terrible people. Well, Mr. Rudolph testified that, remember, he's the guy in charge of the bottling plant, says that you guys should have had shut it down and done a recall. That was in November, I believe, was the testimony in 2020. Doesn't even impact people who were injured in 2018, etc. So you have to have misconduct that's conscious, no, intentional, no, or willful, no, and certainly not clear and convincing evidence to be otherwise. That's why we don't believe damages should be awarded. Check time, 5 minutes. Ladies and gentlemen, the irony of this case is that the plaintiff's causes of action were also packaged, right? They were all packaged together, and we had to take them apart. Had to take them out of that grocery sack and see what's what. And we've unpacked it. And when we came into this case, we said the case is based in large part upon what the experts say the damages are, and we said that it didn't add up. The damages didn't add up. Ladies and gentlemen, we've gone through a methodical effort to lay out what the damages are and what you can rely on. And for that reason, I'm confident now that we've turned it over to you, that you will come up with a fair and reasonable decision on this case on behalf of all the parties. And in that regard, I thank you all in advance. Thank you. Thank you, Your Honor.
Thank you, sir. All right, ladies and gentlemen, it's time for lunch. And you're admonished not to converse amongst yourselves or with anyone else on any subject matter connected with this trial, or to read, watch, or listen to any report or other commentary on the trial by any persons connected with this case, or by any medium of information, including without limitations, newspaper, television, radio, social media. Last but not least, do not form or express any opinion on the ultimate outcome until the matter is finally submitted to you. All right, let's go ahead and break for lunch. And let's be ready to go, say, in an hour. 1 hour.
All rise for the question, jury.